Good afternoon, everyone. Today again we are back with a webinar on copyright. So our today's topic is expression dichotomy in copyright, and we have today with us Advocate Saransh Chaturvedi sir, who is from Allahabad High Court. He is practicing as a lawyer. Some of the few points that we'll be discussing today are how to understand the idea expression, analyzing different jurisdictions, understanding the doctrine of originality, and a few more. So without wasting any more time, I would request sir to take over this session and let's get started.
Thank you so much. Just let me know, share my screen. Is it visible?
Yes, yes.
Yeah. So thank you so much for inviting me in this important webinar. The topic, am I audible, right?
Yes, sir, you're
Yeah.
audible.
Thank you so much. Thank you. So thank you so much for inviting me in this important topic. The topic of idea expression dichotomy in copyright. Actually, we have all read about copyright, and we all know. I mean, I'm assuming that all the audience must be knowing as to what copyright is, but I will be dealing with that also. So, dealing with this idea expression dichotomy forms a very what we can say a principal foundation of the copyright law, not only in India but everywhere in the world. So, while dealing with this idea expression, a common rule that persists with us all that idea is basically a freely flowing thought in your mind. But when we talk about expressions, these expressions are not freely flowing thoughts, but actually they are more of a form of writing or a form in which is inscribed in a material form. So I can have a lot of ideas, but when I start writing those ideas in some material form, then ultimately that idea and that expression of my idea becomes copyright, and I can hold a copyright over it. So ultimately, when we talk about idea are not copyrightable because it is basically a freely flowing thought of mind. And when you are inscribing your idea into some intellectual form or a material form, then it becomes an expression, and that expression is basically copyrighted as per the law. So as I told you that I'm assuming that people here must be knowing what copyright is, but still moving further, I will just be dealing in brief what copyright basically is. So we all know that intellectual property protects your intangible creation, that is the creation of your mind. So ultimately, when we try to deal with this creation of your mind, that becomes very important because when we have a physical form of property that is protected under the Property Act, but when we are having an intangible form which cannot be seen, which cannot be touched upon, or which cannot be inscribed in any physical format, then intellectual property comes into play, which protects your intangible creations. So we have a lot of intellectual property like copyright, patents, trademark, design, layout, semiconductors. And in this Copyright Act forms a very important form because it protects your artistic expressions. So as it is being written on the slide, copyright is a right given by the law to creator of literary, dramatic, musical, artistic work. So any dramatic work, literary work, or an artistic work which you are developing in a material form, or you are expressing it in some form, you can have a copyright over those artistic or over those literary expressions. It is basically you get the right over your expression. Suppose if I tomorrow, if I am thinking of writing a song and if I inscribe it in some material form, that becomes my expression, and I can have a copyright over those expressions. So when we try to deal with these expressions, and when we try to deal with this copyright, basically copyright provides you a bundle of rights. Like you can have the right to reproduce, you can have the right to communicate, you can have the right to adapt or translate your work. You can adapt your work in some other form. So basically, copyright is providing you the right. Nobody else has the right to take your work without your consent. And if he is taking up, you have the right to go to court and you can sue it and you can ask for damages also. So it provides you a certain minimum safeguard of the right to author over their creations, thereby protecting and rewarding creativity. It's just basically intellectual property rewards your creativity. So ultimately, this creativity is being rewarded. Your artistic expression creativity is being rewarded as a form of copyright protection is being given. So this is the basic crux of copyright to all those who are new in this field and who don't know about what copyright is. So you have the artistic expression. So the question arises that which type of artistic expressions and which type of your work can have a copyright protection. And here comes a very important formula and here foundation of idea expression dichotomy, because this is very important, because actually this is the base of your copyright. This is the base on which you seek your protection in the field of copyright. So ultimately, when we try to deal with this idea and expression dichotomy, idea and expression dichotomy, as I will say, that it is very easy to understand, but it becomes very difficult to actually apply this principle in case to case basis, because there are difficulties in demarcating what your idea and what your expression is. Because when we are trying to deal with this idea and expression dichotomy, there comes a situation when ideas and expressions are interlinked with each other in such a format that you are not able to demarcate as to what idea and what expression is. So that's why I told you that this idea and expression is basically very easy to understand and very easy to what you say easy to uh, understand, but yeah, it is very difficult to apply. So basically, when we try to deal with this idea and expression, basically ideas and expressions and all these two words are very ambiguous words. We have a lot and lot of definitions. We have lot and lot of interpretation of these two words. Like you can have a lot of interpretation of ideas. You can have a lot of interpretation of expressions. So this idea as well as expressions have different domain, and both can be interpreted in both in various forms. But I request you not to interpret in variety of forms and stick to one single definition, that idea are basically a freely flowing thought of your mind, while expression is the is your expression of that idea in a material format. If we try to interpret this idea and expression in variety formats, then ultimately we will be confused while understanding this idea expression dichotomy. So ultimately, while you are dealing with such an idea and expression, you need to understand the simple definition of idea and expression. That's the idea is basically a freely flowing thought of your mind, and expression is basically your expression in a material format of that idea. So this is the central foundation, and ultimately why this is so. So ultimately, when if you have a copyright protection on your idea, that it becomes very difficult, because if you are claiming a protection over your idea, then it will have a monopolization of your idea, and that will restrict the free flowing of ideas in the public domain. If I am having an idea to let's say to build something, or to have or to create something, then that idea, if I am having copyright protection over that idea, then it will give an undue advantage to me, right? So that is why the central foundation always says that this copyright will not be protecting your ideas but your expressions. We will be dealing with various examples to understand how this idea and expressions and how this idea and expression will play a role in in society. So basically, this, as I told you, idea is formation of thought. So one idea can be depicted into various types of expressions. Like if I am having an idea to, let's say I am having a movie, or I am producing a movie. So in a movie, I am depicting a hero and a heroine. They fall in love. Villain came, fight, hero won, and hero took the heroine back to home. This is something which is very vague idea, which is freely flowing in the mind. Now, if I am having a copyright over such a script, then it will create an undue advantage over me, so that other people who are having the same, almost the same script, cannot be able to depict that picture in their own sense. So I will not be having an idea, or I will not be having an copyright over this vague idea. This is just a formulation of thought. How I am depicting such hero heroine love, villain coming and hero fighting the villain and taking back to home, how I am expressing it in my own manner, I will be having a protection over that manner, and not the simple vague understanding of hero heroine fighting with the villain taking back home. So you have to understand this idea. Your idea, your formulation of thought does not have to be vague, because ultimately all know that this is something which is happening, hero heroine coming, fighting with the villain and getting back to home, right? So this vague idea will not be getting a copyright protection. The way that you are expressing your movie in a particular form, in a material form, the way that you are expressing the hero heroine, the way that you are saying the dialogues, the way that you are arranging the sequence of your actions and arranging the sequence of your act, constitutes your expressions, and you will have the copyright over that expressions, and not your other vague idea of just having a hero heroine loving villain back home. No. So you have to be very clear onto this aspect, that yes, you have to be clear that ideas and expressions have to be demarcated in such a sense that your idea and your expressions should be there in such a manner that you can claim some copyright protection in it, and just it should not be a vague idea. The context of idea expression dichotomy. So after understanding such an idea expression thing, and you know what idea is, now you know what expression is, and now you know what to protect, you come under as per the context of doctrine of merger and sins affair. These are the two contexts which we can say that helps in idea and understanding the idea expression dichotomy, and understanding how this idea expression dichotomy plays, and what are all the situations and what are all the things where that is obviously comes in a way when you are dealing with such a case. So when we try to deal with the doctrine of merger, then it means, as per the simple definition of merger, this means that your idea and expressions are merged in such a way that it is not being able to get a copyright protection. Now let's say you have an idea and you are expressing something, right? There are some ideas in the world that can be expressed only in few forms. That is something which has to be very clear with all of us. There are some ideas which even if you do a variety of things, that idea will only be subsisting in some particular form. So in this case, idea and expressions are basically merged into each another, whereby you cannot express your idea in multiple forms, but you can express this idea only in some few forms. This, in this case, doctrine of merger will come into play. Doctrine of merger says that in situations where your idea and expressions are not demarcated, they are not able to, you cannot able to demarcate idea, you are not able to give better expressions than that expression that you are already there. Your idea is only there, and you have the option of getting your idea only in some few forms of expressions. Then doctrine of merger says that in this case you will have no copyright protection. Means that if you are having such a copyright protection, if you are having such a copyright protection over such an idea where you are able to express only in some few form, again it will give you the monopoly over that idea. So if, let's say, I have also dealt in some cases, like let's say in Herbert Rosenthal Jewelry Corporation, what happened is this, that the plaintiff was having a jewelry shop, and in that shop he tried to make a B-shaped jewelry ring. Defendant also tried to make a B-shaped jewelry. So plaintiff says that since B-shaped jewelry is his copyright, the defendant should be restrained of making a B-shape. The court said that the B-shaped jewelry is an idea, and it can be expressed in one particular form, that is the B-shaped, right? You cannot have you cannot have a copyright over that B-shaped jewelry. So ultimately, in this particular case, you understand that this idea and expression, the idea of having a B-shaped jewelry, can only be expressed in some form or the other, and not another form. So in these particular cases, you have to understand that when idea and expressions are merged into each another, then you don't have to claim a copyright. You don't have a copyright over that sense, and you have to understand case by case basis that which idea and which expressions are basically being merged into each another, right? So this case is very important. Second case was also Chancellor Master of Oxford versus Narendra Publishing. This is a landmark judgment case. In this case, what happened is that the court says that the mathematical equations and the mathematical formulas, which consist of like Pythagoras theorem and other aspect differentiation and integration, they cannot be copyrighted because they are the equations of the law of nature, and such law of nature can be expressed only in few forms. So if I am having let's say a Pythagoras theorem, I am depicting something, so I will not be having a copyright over the theory or over some sort of things or explanation that I am providing of that theory, right? I can have a copyright the way that I am explaining it, but I will not be having a copyright over the Pythagoras theorem or any mathematical equations, because these mathematical equations are just the law of nature. And while being a law of nature, if somebody gets a copyright over that law of nature, that it will definitely have a monopoly. You cannot have a Newton's laws of motion. You cannot have a copyright over that, right? So ultimately, this is something which is very important, where ideas can be, if ideas is expressed only in few forms, then it is very difficult to have understanding, and if it's very difficult to have a copyright because only few forms of expressions are available to you, right? If variety of forms of expressions are available, then it's no issues. But if an idea is there where only few forms, as I gave you an example of mathematical equation and other aspects, even of physics, chemistry and all, these are not copyrightable because the ideas are only expressed in few forms. Now, I have also dealt with copyright of question paper. Now, if you are having a question paper, if your college is drafting some questions, so ultimately, as per the understanding, the question paper, the drafter who is drafting the question paper, he has the right over that question paper. Now, as I told you, this mathematical formula, we have all studied about maths by 𝗬𝗏𝗍𝗏 or some books, or chemistry by some books. So in these all cases, whether 𝗬𝗏𝗍𝗏 or let's say some other people who is authoring a mathematical question or a chemistry book, whether they have a copyright, yes, they have a copyright. Particularly, you have to understand that 𝗬𝗏𝗍𝗏 or any author who is coming up with a book of mathematics or who is coming up with a book of physics doesn't have a copyright over the theoretical theory that they are trying to make you understand, but they have the copyright over the arrangement that they are doing, over the arrangement that over the sequential arrangement that they are depicting in the book. So they have the copyright over that book, but they don't have the copyright over, let's say, some theory, some physics theory or chemistry theory. So you have to demarcate such an idea and expression into a varied form. When somebody asks you whether you have a copyright over a book, yes, you have a copyright, but you don't have a copyright over some such facts and such circumstances being contained in the book which have a Pythagoras theorem, let's say some equations of laws. So you have to be very clear that even if you are getting a book, you have the right, you have all the right over that book, but you don't have the right to understand this, that mathematical equations, formulas, and physics formulas, chemistry formulas, you don't have a copyright over those aspects. So this is what copyright, this is what doctrine of merger applies in case of copyright. Now, another aspect that comes into the play is the sins affair doctrine. Now, certain scenes, sins affair means scenes to be made. Certain scenes which are mandatory or which we can say customary in nature are not copyrightable. For example, I will give an example. Let's say tomorrow, if I start producing a movie which is of a detective movie. So in that detective movie, I portrays the hero as somebody who is having a black coat, a black hat, and walking in the street. A street is having a black road. This is something which is I am depicting, right? And this depiction is almost similar to the depiction made in Sherlock Holmes also. So the team of Sherlock Holmes, the producer of Sherlock Holmes, cannot come to me and say that you have infringed your copyright. I will say the defense of sins affair, because ultimately these certain scenes of detective having a black coat, hat, and other aspects are basically general in nature, are basically customary in nature. Anybody who is trying to make a movie of a detective will have to depict such a scene, right? So this customary in nature, these certain scenes which are customary in nature cannot be copyrighted. So ultimately, you have to be very clear about all these things, that when ideas and expressions are merged into one another and ideas can be expressed only in some particular form, you cannot have a copyright. If your idea and your expressions are customary in nature, as in the case of sins affair, then also you don't have a copyright over it. So understanding the sins affair and doctrine of merger is very important. I will be dealing with sins affair moreover. Like, why sins affair is there? Because if, let's say, as I give you an example of Sherlock Holmes, let's say if Sherlock Holmes have the copyright over this image of a black hat, black coat, black hat, and a detective walking. So ultimately, what is happening, if he is having a strong, strict right over that image, ultimately I will not be able to use it because he is having the right. But as per the sins affair doctrine, this accept and this doctrine gives you the right to continue endeavor, to frame thoughts, to do else things, whatever you can do from that scenes, right? So it is particularly providing you more room for a creative development. If such rooms is not being there, then ultimately today we don't have any movie left, any with any images. So these sins affair doctrine, if being used in a very particular format, will provide rights to the author to be creative. That is why this doctrine of sins affair is being heavily used in case of artistic expressions. Because anytime when some detective or rather some, let's say, if I am depicting a hero heroine kissing on the top of the mountain, If any other picture is doing the same, they cannot claim a copyright over me, because that is a particular theme is customary, that is particularly common in the public domain, that has to be shown. You cannot have a copyright over such a thing. So you have to understand this idea and expression in case of doctrine of merger and sins appear. Now, can versus universal picture. In this picture, the whole issue was a couple was taking shelter under a church, and a storm was going. So a couple taking shelter under the teen shade of a church, and a storm was going all around, cannot be copyrighted, because this is something which is very particular. This is something which is very known to all of us, right? So you have to be very clear with which kind of genre, which kind of expressions, which kind of scenes you are trying to claim copyright over. Such scenes which can only be expressed, or rather which is only particular or which is common in the public domain, cannot be copyrighted. Nobody can give you a monopoly over this thing. Another case which is not being I have not written here was Alexander versus Haley. Alexander came out with a very famous book called Jubilee in 1960s, I think. And after getting a copyright registration, Haley read the book and also made that similar kind of book. He also made a similar kind of book and asked for a copyright registration, and he was granted copyright registration. Alexander filed a suit against Haley, saying that my book and his book is almost similar, and we both are dealing with the similar situations. And since my copyright is before, so he is having a copy, he is doing a copyright infringement. The court says that there is no copyright infringement. Why? Because first of all, understand what was the book was. The book dealt with the slavery situation in USA, in which Alexander tries to depict what all life slavery was, how slavery was living, the culture of slavery, the sufferings of slavery, the facts and all the circumstances. Similar similarities was being depicted by Haley. Haley also says the same suffering, the same cultural significance, how they are living, how they are suffering, and what are all the circumstances there at that point of time when the slavery was going on. So these two similarities was there. The court says that these two similarities are basically sins affair, because ultimately these scenes are of a particular form and these scenes are in the public domain, and nobody can have a copyright over that particular thing. Because suffering of same, say if you are making a movie tomorrow on slavery, then you have to show some sufferings of slavery, you have to show the cultural significance, you have to show what are all the circumstances. So these all are parts which forms a sins affair, which forms a scenes to be made, which is very much obvious in the public domain, and nobody has the right over that particular scenes, especially to gain monopoly. So the court says that the indispensables the treatment, how both the book are showing the treatment of the slavery is basically the same, and you cannot have a copyright over onto this, right? Because if you have a copyright, again it will be coming under the context of monopoly. So you have to be very clear onto this, that the scenes to be made, the scenes which are very common and which are very particular in a public domain, and moreover the particular things that is considered under the idea and expression merger, these two aspects you have to be very clear while understanding the idea expression dichotomy. I will make you more clear about the sins affair and other thing. This was the case where Bill Diodata photography versus Kate Spade. The image that you are seeing in the right and left are almost same. So what happened is that the plaintiff says that the defendant, while having a similar image, have infringed the copyright. The court says that it is not the case, because court remarked that such a thing, or rather such a particular form of depiction of a woman leg sitting on a toilet and showcasing the jewelry, or showcasing the something which she is wearing, or some shoes for an advertisement purpose, cannot have a copyright. Because ultimately if you have a copyright over such an image of a woman sitting on the toilet and showcasing the jewelry or showcasing the fashion accessories, then ultimately this copyright will instill monopoly. So in this case, it's a very good example that a similar image was also denied copyright protection, and was also said that it was not a copyright protection only because of the fact that such a particular thing is in the public domain, and whatever and however tomorrow if anybody else is showcasing the fashion accessories of, especially of legs fashion accessories, then ultimately this such a type of image comes in the form of public domain, and nobody has a strict copyright protection over those images. So this was also a very famous case, and which is also very important to understand how similar image can also be considered as an idea expression dichotomy, as can also be considered in the as an example of an idea expression dichotomy. So this was the fact. Now let's see about some other aspect of sense affair, and let's see about other examples of sense affair. Tomorrow, if let's say I am making a cookbook, I'm trying to provide you some recipes, and if I'm trying to make a cookbook, so whether I am having a copyright or not. So it's a very confusing. Let's say tomorrow Sanjeev Kapoor is having a cookbook and he comes out with a cookbook with having different recipes. And tomorrow, if I went and bought the book and I copied the recipes and I published one more book, so whether I am having a copyright infringement? Two things. First of all, if I am taking the recipes, if I am taking the ingredients, if I am taking something, the descriptions, if I am taking the quantities of how it is being used, how much this material or how much that food has to be dealt in, these particular descriptions, ingredients will not constitute a copyright infringement, because this is something, again, it will come under the sense of fair. Your ideas and your expressions, even if it is an expressed, but that idea is in particular in a society, in a societal domain, in a public domain, and you cannot have a claim over those particular ingredients and descriptions. Now let's say if I even copy some more recipes where it is visible that Sanjeev Kapoor is trying to provide some descriptions, or he is trying to provide some suggestions over those particular recipes, and even I am copying those particular suggestions and descriptions which he is telling apart from ingredients and descriptions and how to make the food, then I will be having a copyright infringement. So you have to understand, if I'm tackling with such an infringement, if I'm tackling with such a ingredients, descriptions, how many quantities of which food has to be there, such a thing will not invite my copyright, will not invite copyright infringement. But ultimately, when we are having some, when I am copying some descriptions, when I am copying some suggestions that he's giving apart from all these ingredients, ultimately that will constitute a copyright infringement. So you have to be very clear while copying such a cookbook recipes. Again, one thing more, when you are having a cook and you have taken a cookbook recipe and you are making some food, then no copyright infringement has to be there, because that is in a book format and you are making it in a physical format, so that no question of copyright infringement arise from there. So you have to be clear about this. Now, if you talk about maps, you have seen various maps being there, like Google Maps and other aspects. So whether you have copyright over the maps, probably no, because the house, the roads that are going on, all the arrangements, everything are there, and which cannot be changed by anything. Even if I'm copying a Google map, I will not be constituting any copyright infringement, because ultimately what happens is that when we are trying to deal with this copyright infringement and when we are trying to deal with such a maps, then this map particular work, then ultimately and definitely that particular description, the copying of that particular description will come under the purview of this copyright infringement. So you have to be very clear. The conventional map, if you are copying the conventional map that you see in the on the variety of places, in stationary places or even in online, you don't have to fear about copyright infringement. But if you are copying some other aspects or some arrangement that is being associated with that map, ultimately you can have a copyright claim, or you can be troubled in copyright infringement. Now, another thing about history books, there are a lot of cases about history books in this public domain. And what constitutes such a copyright infringement is that, let's say if I am trying to publish a history book, and in that history book I thought to take a life of some ruler, and while taking the life of ruler, I studied hard. I studied for like a couple of years even to understand what was the life of ruler. And if I develop a book, now let's say a person A comes, read my book, and he depicts in another form, and he depicts the facts in his own form, he expressed in his own form, and he came out with another book, whether he has infringed my copyright or not. You have to be very clear that even if I have spent around 2 to 3 years of time in structuring what was the life of the ruler, you have to be clear that these such a structuring of lives are just the facts. Even if it is not there in the public domain, even if it is so typical, to chalk out what was the life of the ruler, still they are in the public domain. So you have to be clear that such a public domain and such a thing which is there already in the public domain, such a facts basically also constitutes a sense affair. And even if I have worked a lot, and if he is copying my facts, my structuring of the facts even, then also I can't have a copyright claim over it, because ultimately these things that are copied by him are just the facts. So it has to be understood which condition and which expressions are being taken care of, and which expressions are being constituting a copyright infringement, and how which ideas are there. So by various examples like cookbook, history, maps, and other aspects, you must be almost clear as to how to constitute an idea and how to constitute an expressions, and how to demarcate this idea and expressions into two part. Basically, an idea and expression dichotomy, in US, Baker versus Selden was the case, in which Baker was the person, the plaintiff, came out with a book which was basically of an accounting book. And in that book, he provided the systematic accounting arrangement, and he annexed these all arrangement in a particular form with the help of some lines and headings. The defendant also came up with the same book explaining the same idea of accounting arrangement, annexing it with the same things, but the lines and headings and all the rules and regulations that he's been using was different. The context of accounting system was same, but the way that he's expressing was different, right? Yes, so the way that he was expressing was different. So what happened is that when you are trying to deal, hello, am I audible?
Yes, you are.
Yeah, sorry. So when you are trying to deal with such a Baker versus Selden, so ultimately what happens is that when this such a Baker and Selden case was there, the court says that in spite of the fact that the accounting system and accounting things was similar, the system of arrangement was similar, but both the plaintiff and the defendant has used both the structure in a different format and with different rules and headings. So this will not be constituting. The idea is the accounting system, while the expression is not the accounting system, but the expression is the way that you are expressing with the rules and headings. So this Baker versus Helding was a famous case which construct the idea expression dichotomy in US. Similarly, in Donogh versus Allied newspaper, it is also a very famous case in which a very famous question used to arise, that if I am having an idea and if I used to explain that idea to a person, and if that person develop that idea into an expression and he earns money, can I claim? So the answer to this is no. Donogh versus Allied newspaper, the court said that in this particular case, when you are having such a production, or rather such a work, if you are having an idea in your mind, that does not constitute work. The work will not be under the condition of your ideas which is already in your mind, until and unless you reduce it to any writing format. So if you are having a brilliant idea and if you communicate your idea to somebody else, and if in that form is, if you are communicating, let's say, to your friend, and if he is making some expression over it and he is earning money, you cannot claim any such copyright infringement, because it was only your idea and not your expression. You expressed it in your own format, he expressed it in his own format, and your idea being in your mind will not be constituting as any work. Later we say literary work, artistic work. So you are not having a work in that sense. So this was the case of UK. And India, it was RG Anand versus Deluxe. Since we all know the similar arrangement of idea and expression dichotomy was explained, whereby the context was same, that ideas are not copyrightable, but the expressions over it are copyrightable. So copyright in terms of, let's say, in their book of art, medicine, author, art, medicines, or mathematics, gives the author a particular right over the book, but not the right, but gives the right of the to the author for that expression, but not the right to the mathematical equations or medicinal formula funda, right? So you have to be clear about such a context of idea and expression. You have to be clear about the doctrine of merger. You have to be clear about the sense affair while dealing with this. If you have any confusion till date, until now, please let me know. If you want me to repeat something, I will repeat. And then we will move to the abstraction, filtration, and comparison test. Akshay.
Sure, sir. We'll just check if there are any questions by the participants. If you had posted anything earlier, though I don't see any chats here, so you can post your questions now. You can also post it in the Q&A box, which is given there.
Hmm.
As of now, we don't have any questions, so I think we can move ahead.
Okay, so well, I'm not able to see myself. Have you unpinned it or not? Just wait. Yeah. So now understanding this idea of expression dichotomy, there are lots and lots of tests, and there are lots and lots of what you say of each and every court in various domains and districts have taken up variety of tests and how to ascertain which is an idea and which is an expression, because this idea and expression, as I told you, is difficult to understand, sorry, difficult to apply, but very easy to understand. Now, abstraction, filtration, and comparison test. Now, when we try to deal with this abstraction, filtration, and comparison test, this test helps you to determine what is an idea and what is an expression. Why I am dealing with this test is because this test is very famously used in various domains, especially in US and UK as well. So what this abstraction, filtration, and comparison test is all about. So let's take an example of a computer programming. This test is basically used in computer programming. So let's talk about computer programming. So when we are trying to deal with this computer programming, there are a lot of source codes and there are a lot of programming code in a computer program. So your computer program will have some, let's say your computer program will have some result, but that result will come from a variety of source code. That is something which is very clear. Let's say, for example, a plus b plus c plus d plus e is equal to 2g. So this context of program, the typical programming code that you are having is your result of a program, but not your source code. I will again try to make you understand. If you are having a computer program, and in that computer program, you are having different coding purposes. For different coding purposes, you are having some A, B, C, D, E, F, G. In these cases, the source code that you are using in the computer program is common. Let's say if you are using a plus b plus c plus d, a, b, c, d are common. How you are using or how you are constructing a plus b plus c plus d constitutes your main programming code. Is it clear? I think it is now clear. So the code will abstract the source code, and the code will abstract your basic, the typical programming code which gives the result of a program. This is called as abstraction and filtration. The code will try to understand that what actually are unprotected elements in the particular programming code, and what actually are your particular protectable expressions. Now again, I'm giving you an example. Let's say a plus b plus c plus d. So a individually is an unprotectable element because it's a source code which can be used by all. B can be used by all, C can be used by all, D can be used by all. But ultimately, how you are arranging this a plus b plus c plus d, either you're doing a plus c plus d plus b, whatever, this arrangement and this particular programming code constitutes an expression that is protectable, but not an individual protection of a, b, c, d. This is what is abstraction. The code will first of all abstract the unprotectable thing with the protectable expression, right? Moving further, filtration. Now, filtration will be used as per as we have understood, the doctrine of merger and Sin's affair. Now, in that programming code, again the code will go into the filtration test. It just means filter. So, while dealing with such filtration test, the code will say that okay, fine, the abstraction is done. While doing the abstraction, we will also see which idea can be expressed only in few forms. Again, doctrine of merger will come into play, that okay, fine, these are the ideas which can be expressed only in few forms, hence not copyrightable. So filtered, it is filtered. Again, court will go to Sin's affair, that which are all the things which are already being in the public domain and which are necessary. Sin's affair, customary scenes. So again, it will be filtered out, and other aspects. So the abstraction is done, the filtration is done, and the comparison will be done. So again, I will be giving you this example. Let's say a plus b plus c plus d is there. This is abstracted. The protectable expression is being abstracted from your unprotectable ideas, right? While doing this, The court will filter what are all the ideas which can be expressed only in a few form, that's a doctrine of merger, and what are all the ideas which are customary in nature, that is sincere. So it will be filtered out, the abstraction will be filtered out, the filtration will be done, and after getting filtration and abstraction, the comparison will be done by the defendant's work. Let's say if there is a case and there is some other programming code which alleges that you have infringed the copyright, then ultimately that copyright infringement and that particular what you say your programming code and the defendant's programming code, that will be compared after getting the abstraction filtration. So what is the main purpose of such a test is to deduce in such a sense that okay fine, you are abstracting everything, you are abstracting in a sense that okay, you are abstracting the ideas which are unprotectable, you are abstracting the expressions which are protectable, and while protecting and while abstracting you are filtering the ideas which can be expressed only in few minors, doctrine of merger, and the ideas which are customary in nature, since appear. You are excluding all these ideas to come to a point where you have only the protected expressions and not the unprotected expressions from that. You have only the protected expressions, and then after getting into it, you are now comparing with the defendant's work. So in this case, you are abstracting, you are filtering, and you are comparing. Now these three constitutes, and these three will not, I will not say that it will definitely help, but it has definitely helped in variety of cases how to deal with how the demarcation of idea and expressions. So this abstraction, filtration, and comparison test is very important to understand. It is very confusing also. So if you have confusion, I can repeat it also. But this abstraction filtration test is largely used within different jurisdictions to understand and to differentiate what idea is actually and what expressions are actually. Akshay, if there is any confusion with this test, please let me know.
There is something in chat. If someone is coming up with their own recipe and some other person copies the exact recipe but gives the food item a different name, will it be a copyright infringement?
Please repeat. If somebody is having a recipe,
if someone is coming up with their own recipe,
okay,
and some other person copies the exact recipe but gives a food item a different name, so recipe is same and name are different,
no,
will it be a
no. This is something which is very common, that if you are having a recipe, let's say if you are making some food, let's say a famous food like let's say kadai paneer if you are making, and if you are having a different recipe for the same, and if I am copying it, is getting into same ingredients and everything, and I am doing it in my own, then it's no, there cannot be any copyright until and unless you are also copying some suggestions or some unique descriptions that they are giving. So you have to be very clear about this distinction, that if you are copying some recipe, you are copying some ingredients, you are copying some how much food has to be there, how much ingredients has to be there, how much things has to be maintained, and how much, what is the timing of getting into making the food. These all things are just in the public domain, which will come under the customary ones. But as soon as you start copying some that kind of a recipe or that recipe which constitute a unique description that they are giving, a unique description regarding taste, a description or a suggestion regarding some circumstances, that particular descriptions and the suggestions will be constituting a copyright infringement. But copying a recipe just for the sake of making your own, even if it is unique, then also it will not be constituting a copyright infringement, because ultimately it will come under the sincere doctrine, customary in nature. Akshay.
All right, we don't have any other questions right now.
Okay. So nextly, we will move on further to the very famous concept of the degree of creativity. Just wait. Yes. So now you are very much clear about your idea and your expressions, and now you are clear about how your expressions has to be there and how it is differentiated from the context of idea. Now, while dealing with this idea and expressions, the question arises that whether all expressions and all expressions are copyrighted or not. Here, the more important perspective is of the doctrine of originality. So we have different doctrines of originality being developed at times in different jurisprudence, and basically we used to discuss three doctrines, that is of UK, US, and being in India, we discuss India. So what are all the doctrinal approaches? Because what creativity is there? How creative you are being there by making your particular expression is the most important thing while constituting the originality. Now, UK is sort of the bro theory. Now you understand, you have to be very clear about this originality. You have to be clear about how you have to be in this originality context. And while making some expressions, you have to be clear about this originality has to be at such a level and has to be at such a diligent level that it should constitute some originality in itself, and not in just in the form of an idea. The expression has to be created in such a sense that it has to be an original creation of the author. So while dealing with this originality, UK uses the sweat of the pro theory. While before discussing, I will discuss this case. This case comes up in the UK of University of London Press versus University Tutorial Press. In this particular case, what happened is that while dealing with this whole issue of originality context, University of London Press hired three professors, and those three professors took up the work of getting a question paper ready. The University London Press got the right and got the whole copyright over that particular work. And what they did is that those three professors tried to make a question, the performer of the questions, and while making the performer of the questions, they did their job. The University Tutorial Press took those questions. I think they took half of the questions and then published their own book. The University London Press claimed copyright infringement against the University Tutorial Press, stating that the questions that were being copied by the University Tutorial Press were being developed by the professors in the University of London. And since copying it without consent from the University of London by University of Tutorial, then it constitutes a copyright infringement. University Tutorial says that such a infringement cannot be there because these questions and these things are basically question of common type, and it is not a unique questions. So ultimately you cannot have a copyright over it. The court says that in spite of the fact that these questions are unique, the framing of the question requires some form of effort, some form of labor in it. That's why sweat of the brow. So some form of labor, if that particular work is expecting, and if that particular work holds some form of labor intellect, then ultimately the copyright will subsist in the plaintiff. So plaintiff was not denied the copyright, and the defendant was being charged by the copyright infringement. So ultimately, what sweat of the brow is that this doctrine explains us that when we try to deal with this originality context, and when we try to deal with such a context of originality in some artistic work, the labor and the intellect has to be taken account in. This was heavily debated, and in variety of cases, such a sort of the broad theory was also been negated. But as of now, if you want to understand this much only, that this doctrine explains that any work to be in context of original must require some labor and intellect in it. And that is how the originality context of Sweat of Debro in UK came into existence after this case. Similarly, US, in the Feast publication was a rural telephone, the case was that rural telephone was a company which provided telephone services in a particular area. And in that particular area, what they did is that while getting into some services of telephone, they came up with a directory. That services that they provide in an area, they have a directory of phone numbers which they came out with, of that particular area. Feast publication was also getting into the domain of telephone services and also wanted to provide some directory. So Feast publication went to rural telephone to ask to ask for a license to use the directory that is being published by rural telephone. Rural telephone says that no, we cannot have. They denied the license to the Feast publication. What happened is that after getting denied for license, Feast publication copied the rural telephone directory without their consent, and they hired some people. They investigate, and what they did is that after investigation, they verified the data and they provided more information in the directory. Means the directory having name and number was not only having just two informations, but since it is verified, it is investigated, more information was given by the feast publication. Due to this more information being given, such a directory was becoming famous, became famous in that area. People started buying it because it is providing you more information. Then the rural telephone feast publication was claimed the copyright infringement by the rural telephone. Ruler said that the directory which he has or which they have maintained and which they have been publishing in the area has been copied by the feast publication. The US court in this case rejected the suit of the pro theory. They said that only the amalgamation of some data of that particular area people living and making a directory will not constitute a copyright over it, because rural telephone is doing nothing, but they are just amalgamating and they are just collecting all the informations and making it in a book. While what feast publication is doing is that in spite of taking the directory also, they are working over it, they are investigating over it, they are verifying the data. So ultimately, the feast publication and the feast publication is doing something, means modicum of creativity. They are providing some modicum of creativity in that sense, which provides more room and which provides more artistic or more creative nature of feast publication. The rural telephone was only collecting the data and inscribing it in a material form, but feast publication was doing more, like investigating and doing more. So US, while rejecting the suit of the bro theory, came up with this modicum of creativity, that creativity has to be there. So you understand the margin of originality in UK is very less, because it's only deals with the context of having a labor and intellect. While when you talk about US, it tries to talk about the creativity. It tries to talk about the creative in nature. So this domain and this margin of this originality context in both US, UK, and US are poles apart. Now India is in middle. It's not as lenient as UK and is not as typical as US. So it comes with a famous phrase of flavor of minimal requirement of creativity. The famous case of Eastern Book versus DB Modoc is very important, whereby the famous we all know SCC and EBC. So they contended that the defendant was using their judgment and publishing it in their own form in CDs and in online format also, and providing it in a lesser prices, which is obviously the copyright infringement of Eastern Book. The defendant said that the judgments are there and they don't have any copyright. The Eastern Book doesn't have any copyright. What the defendant says, the court ruled that in spite of the judgments are there, the Eastern Book are working on those judgment, are working on those particular thing, are explaining in a more typical format, are suggesting and also are coming up with new format and new arrangement of such judgments, in which again they are doing creativity. So ultimately, copying of those judgment by by the defendant of Eastern Book Company will constitute an infringement. So this also is very important, because particularly the court was totally tilted towards the US ideology of modicum of creativity, and inspired from US, tried to deal with such a case that, okay, even if it is being copied, the Eastern Book is doing something. In Eastern Book is what you say creativity, a minimum requirement of creativity is being done by Eastern Book, and hence they constitute copyright, in which, and copying of such a thing will constitute a copyright infringement. So understanding this idea expression dichotomy and understanding such an idea expression dichotomy with the particular context of doctrine of merger, as I told you with variety of examples, with the particular context of having a, let's say, the sense affair, with the examples I told you, and after getting into all these things, the abstraction filtration test, and after getting into even the test also, you understand the originality context. So these things are basically very important to understand before getting into a copyright case, because these forms a very important foundational principle of copyright. And since I have not dealt with various cases, there are a variety of cases, but since the time constant was there, I have not dealt with such cases. But yeah, later on, if get another chance, then I will also be dealing with some of the cases which is very important. In 2020 also there were a couple of 2 or 3 cases in Delhi High Court and Bombay High Court, which was very important for the context of having a what do you say, of having this context of this idea and expression dichotomy. So these all things are there, and I feel that it is more than enough for me to stop here. And if you have any questions, and if you have anything thing turned confused, or if you want me to repeat anything, please let me know. Akshay.
Thank you so much, sir. I'll just wait for 2 to 3 minutes. So if anyone has any questions,
Yeah.
or if you want anything repeated, please let us know. We'll try to answer most of your queries. We'll just wait for 2 minutes.
Yes, yes, yes.
And yeah. If you can please elaborate, just a second. If you can please elaborate on abstraction, filtration, and comparison test once more.
Okay, so while dealing with this abstraction filtration test, this is basically did as I told you in computer programming software. So as the name suggests, first of all, you need to go for an abstraction and then filtration and then comparison. The abstraction is always there for abstracting your idea, the unprotectable idea with the protectable expression. I gave an example of A plus B plus C plus D. It's a hypothetical example. So the court will say that the A, B, C, D in itself will not be constituting any expression. These are all the ideas, which are basically called as source code in the computer programming. So these A, B, C, D are just an idea. And the way that you are abstracting, the way that you are framing, the way that you are expressing it in a particular form is an expression, is a protectable expression. So the court will try to divide such a unprotectable idea with form of your protectable expression. They will say that the arrangement, okay, this is a computer programming. This is something which is very common. This is something which is not so common. This will constitute an expression. So abstraction will be done like this. While doing the abstraction, the court will filter it out. While using the filtration, the court will keep in mind the same Sins affair and the merger doctrine, that if you are having the merger doctrine is there, if some idea can be expressed only in few ways, or if some idea can be expressed as a part of customary, in both the cases which I dealt right now. So in both the cases, they are not copyrightable, right? So the court will filter it out, those ideas in terms of doctrine of merger, which can be expressed only in one way, or those ideas in terms of Sins affair, which are customary in nature. They will filter it out, and then they will come up with a particular program which is totally an protectable expression and which does not constitute an unprotectable idea. This is something abstraction. They will abstract everything. They will abstract the public domain. They will abstract the thing that are in customary nature. They will abstract those ideas which can be expressed in only few forms. And after doing all sort of things, they will come up with a particular expressions which is totally been protected. And after getting into the protected expression, they will compare with the defendant. Like if there is any case, then they will compare this protectable expression, not unprotectable ideas, since they have already abstracted and filtered out. So they will be protecting and they will be comparing with that particular expressions with the defendant. The comparison will be done, and this is how the idea and expression dichotomy will be there, and this is how the court will come into a judgment. So this is the in short, this is what the abstraction filtration test is there, if it is clear to you. Akshay.
Yes, right. Thank you so much, sir. I don't see any more questions.
Yeah.
So I think all the queries have been answered.
Okay. Thank you so much for this.
Thank you so much, sir, for taking out your time, and thank you so much all the participants for taking out your time and
Yeah,
attending the
I
session.
can also, if anybody wants to connect with me on mail, if anybody has a confusion, they can also mail me up. Yes. Is it
All
visible?
right. So yes, the email is visible on the chat box, so you can check it up. And I'll conclude the session in a minute.
Thank you so much. Thank you.